Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is a continuation of the changes to the Georgia Association of Realtors contract forms for 2020. Please see all the videos in this series for a presentation of changes to those contract forms, and please check out the classroom classes that are being hosted by Maximum One Realty companies throughout Metro Atlanta. The link is below. It's www.registerforreclasses.com. Then click on your geographic area to find a myriad of classes throughout December, January, and rolling into February. So today we are talking about the changes that the GAR Contracts Form Committee made to the listing agreement. Now, these changes have been made in all the listing agreements, the exclusive listing agreement, non-exclusive listing agreement. So I'm just going to cover the changes that they made. So here we go. The first change they made is when it talks about the listing agreement in and of itself and any changes to that listing agreement. It states that those changes must be in writing. So here's the verbiage under paragraph B1, where it talks about exclusive listing agreement. The addition that they made, it says, this agreement and the terms and conditions herein may not be amended, modified, or waived except by the written agreement of the broker and the seller. Any agreement to terminate this agreement or any other subsequent agreement of the parties relating to this property must be in writing and signed by the parties. So a few years ago, they did have termination language in there. Then, more recently, they took out the termination language. The issue is we were still having sellers terminate the listing agreement by some means or another, and it got really a little bit sticky as to, well, was the listing agreement terminated or not? What were the terms of the termination? What were any financial obligations to the broker? Did those get resolved or not? And there is, just so you know, there is a mutual termination of brokerage agreement and there is a mutual termination of brokerage agreement that are available in your GAR contract package forms. But so what they have done this year is for the 2020 listing agreements, GAR has added back in that specific verbiage that anything must be in writing, but it specifically states that any agreement to terminate this agreement or other subsequent agreements to the parties relating to the property must be in writing and signed by the parties. So that will make things a lot more clear as to a seller actually terminating a listing agreement or not. Then the related to, so that's new verbiage that has been added in there. Then what has been in there, and this has been in there since, this has been in there for a couple of years, that the listing agreement does get extended with the broker under two conditions. One is, let's say the listing agreement expires, but you're under contract, and the closing date for that contract falls after the initial expiration of the listing agreement. Is there still a listing agreement in place or not? And the answer is yes, the listing agreement does stay in place through the closing of any contract. Then there is another provision, and again, this has been in there for a while, that states that should the listing have gone under contract for a certain number of days and failed to close, those days under which the property was under contract but didn't close gets added to the length of time or the expiration of the listing agreement. Now, that had been in there as an automatic extension of the listing agreement. Last year in 2019, GAR kept that it was an automatic extension in there, but they added the verbiage that the broker must send notice of that extension, and that notice of the extension, again, for when the property had been under contract but didn't close, must be done in right. Well, that the broker had to send notice of that prior to the end of the expiration of the listing agreement. So basically that just left it up to the brokers to send notice in the general notice form. So what GAR has done for 2020 is GAR has created a new form, a new notice form, and it is F-158 called Notice to Extend Listing Period. So now there is a specific form for you to use when you are going to send notice of the extension of the listing period for the time frame under which the property had been under contract but failed to close. All right. Now there is a whole nother, a new section under the marketing paragraph. So this is in paragraph B5 under marketing, and it is paragraph E. And let me read this to you. No marketing by owner. Owner is encouraged to communicate the availability of the property for sale to friends and other acquaintances. However, since the broker has been hired to exclusively market and show the property, owner shall not, with respect to the sale of the property, prepare and distribute marketing materials, hold open houses, put up signs regarding the property, create websites for the property, prepare flyers, brochures, or videos, or engage in similar activities without the prior written consent of the broker. So that is a brand new paragraph, basically telling the seller that when they hired you to market the property, they hired you exclusively and they can't do it on their own, solicit buyers on their own without your express written permission. All right. Now, the next section is just a little bit more of a formatting change. It's under paragraph C4 where it talks about the limits on the broker's authority and responsibility. They've changed that just a little bit and teased out the liability paragraph, and that was within there, and they made that a whole separate section. This is very similar to the purchase and sale agreement, this section that I went over in a video on the changes, the 2020 changes to the purchase and sale agreement. But basically there is a whole new paragraph. Again, it had been in there, they just teased it out a little bit, and it is paragraph 5. It is all bold and all caps, and it talks about limit on broker's liability. Seller acknowledges that broker A shall under no circumstances have any liability greater than the amount of the real estate commission paid hereunder to the broker, excluding any commission amount paid to a cooperating real estate broker, if any. Or, if no real estate commission is paid to the broker, then a sum not to exceed $100. And B, notwithstanding the above, shall have no liability in excess of $100 for any loss of funds as the result of wire or cyber fraud. So again, they just that's just a formatting change where they teased it out and made it a separate paragraph in bold. All right, this is a brand new section under the listing agreements, and it is under C7 miscellaneous paragraph F. This is a statute of limitations, and this is, my understanding, is based on case law regarding the statute of limitations is the time frame within which party can bring suit against another party based on what the lawsuit is. So in this one, statute of limitations, brand new paragraph, it states, all claims of any nature whatsoever against broker and or their affiliated licensees, whether asserted in litigation or arbitration, must be brought within 2 years from the date any claim or cause of action arises. Such actions shall thereafter be time barred. So again, this isn't a law that GAR is creating. This is just a clarification of the law that does exist by case law regarding the time frame within which a seller can bring a suit against a broker or the affiliated licensee in either litigation or arbitration regarding the listing agreement. So that has been put in there. And then really the only last change, and this is a universal change regarding the beware of cyber fraud paragraph. That verbiage has been reworked a little bit. Again, I really discussed this in depth in the video on the 2020 changes to the purchase and sale agreement as far as you as a licensee, what are some things you can do as a point of practice regarding cyber fraud. But let me read you the actual verbiage that is now it's in all the forms. Any form that mentions cyber fraud, this change has been made universally. So it's in the listing agreements, the buyer agreements, purchase and sale agreements, so forth and so on. So what it states is fraudulent emails attempting to get the buyer and or seller to wire money to criminal computer hackers are increasingly common in real estate transactions. Specifically, criminals are impersonating the online identity of the actual mortgage lender, closing attorney, real estate broker, or other person or companies involved in the real estate transaction. In that role, the criminals send fake wiring instructions attempting to trick buyers and or sellers into wiring them money related to the real estate transaction, including, for example, the buyer's the cash needed for the buyer to close, and or the fraudulent or the seller's proceeds from the closing. These instructions, if followed, will result in the money being wired to the criminals. In many cases, the fraudulent email is believable because it is sent from what appears to be the email addresses or domain of the actual legitimate company or person responsible for sending the buyer or seller wire instructions. The buyer and or seller should verify the wiring instructions sent by email by independently looking up and calling the telephone number of the company or person purporting to have sent them. Buyers and sellers should never, ever, 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 emphasis added, call the telephone number provided with wiring instructions sent by that email, since they may end up receiving a fake verification by the criminals. Buyer and sellers should be on special alert for 1, emails directing the buyer and or seller to wire money to a bank account in a state other than Georgia. 2, emails from a person or company involved in the real estate transaction that are slightly different, often by one letter or number or character from the actual email address of the person or company. And as I mentioned previously in the other video, another thing the bad guys are doing is they are also again, I forgot the terminology. I think it's spoofing, but they are also sending text messages to our buyers and our sellers with alternate wire instructions. And the number that this text message comes from is the exact number of one of the legitimate parties. It is the exact number of the closing attorney or the mortgage lender or even you guys as agents. So you have got to make sure that your public people know, never ever trust wire instructions that they get electronically. And you need to deliver wire instructions in person, by hand, or by U.S. mail. Never electronically yourself. Never be the messenger of wire instructions from the closing attorney. Those are issues that need to be handled without your involvement as the agent. So that's about it. Those are the changes to the listing agreements. So comment below what you think. Thank you guys so much for watching. Stay tuned for more 2020 changes to the GAR contract forms. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.